to thank everybody for coming out this evening. We have a packed program and I think a lot of good information. Everybody should have a handout, actually 2 handouts, which will contain a little bit of what we're covering, plus some checklists and other information that should serve as resources to you. Can everybody hear? Okay, way in the back there. Good. Then we're doing pretty well. We're going to have about 5 speakers today, so we're going to try to move along. If you have questions, please feel free to stop me or any of our other speakers as we go, and then we'll be around afterwards to answer any questions that you may have. Tonight's program really focuses on estate planning, and it's meant to give you an overview of some things to think about or to consider, and hopefully then go to your attorney to develop a plan that makes the most sense for you and your situation. Some of the things we cover may not apply, but then again, some may. So, as I say, we're going to cover kind of the gamut this evening, and then the support for this is in your handouts. Now, estate planning is basically just figuring out what to do with your stuff. I think people sometimes make it a lot more complicated than it needs to be. But your estate is just all of your stuff, and estate planning is what to do with your stuff. Excuse me. One of the things that I think people often misunderstand is that estate planning is not just for when you pass away, but it's also how to protect your assets while you're alive, and particularly if you're incapacitated and can't manage them for yourself. So a lot of what we want to talk about tonight, it's not just about passing assets, but it's also about preserving them. Now, estate planning really has 3 facets to it. 1 is control. 2 is what are you trying to do? What's your vision? And the first thing that we need to do is to sit down and really start to figure out what are we trying to accomplish. And I think often people jump into this kind of preparing documents without really thinking about what the end game is. So in your handouts, we've included a checklist to try to start to plan and figure out where you are today and where you want to go. Now, most of estate planning is going to involve compromises. If we want to minimize tax, we probably have to give up control. If we want to keep control, we may have to give up some tax. We may have to give up some other objective. So, when you look at the triangle, we're basically balancing what we're trying to accomplish with minimizing taxes and ultimately accomplishing what we want to do. Now, one of the things that people sometimes look at with the estate planning is philanthropic types of objectives. Our firm's core value is to make people's lives better, whether it's yours as our clients, it's our community, or it's our team members. One of the programs that we started last year was something called Carver Cares. Carver Cares was developed to highlight some of the local nonprofits in Lake County, let people know what they're doing, and then also to help support them monetarily. So at each of our events, as many of you know, we have a partner. Tonight's partner is Big Brothers Big Sisters of Lake Geauga and Ashtabula County. There is some information on your tables. If you choose to support them monetarily, monetarily, we will match any donations made in the next 30 days. But again, the primary purpose of introducing the nonprofits to you is just to give you a quick overview of some of the people that are in our community. When we start looking at estate planning, the first thing is we need to actually do it. It's amazing how many people don't have a simple will or durable medical power of attorneys or any type of documents. So one of the questions we get asked, so what do I need? What I would suggest is you need a six-pack, not these, but six-pack of documents, which would be a durable power of attorney, a medical power of attorney, an advanced healthcare directive, which used to be called a living will. I call it Unplug Randy. A will, letters of instruction, to really tell people what you'd like to happen, and then possibly a trust if it's appropriate. And certainly trusts are not a panacea for everything, but in some situations they can be very valuable types of documents to have. Now, something that's changed is the amount of money that you can pass on without any federal estate tax has gone up pretty dramatically. As of 2014, the amount's about $5.3 million. So, the first $5.3 million, there is no federal estate tax. Ohio, in 2013, got rid of their state estate tax, which is why we called the seminar, Why Ohio's a Great Place to Die, or maybe live. But it does have some of the most favorable planning opportunities in the country. And Amy and Ron are going to touch on this in a few minutes, a little bit more detail. Now, the other thing that happened in 2010 was something called portability. It used to be that when someone passed away, their credit, if not used, got lost, unless you did some planning, AB trusts or what are called marital trusts. As of now, if a spouse does not use their $5.3 million, by filing an estate tax return, the unused portion goes to the surviving spouse. So effectively, married couples today can pass on about $10.6 million without tax. And that's important because prior to 2010, when we looked at planning, when the attorneys looked at planning, a lot of it was focused on how do we minimize the tax. And now we can focus on things like, what do we really want to do? How do we want to help kids and grandkids? How do we want to protect ourselves? So the estate tax limits have gone up pretty dramatically. Now, one of the things a lot of people don't think about are digital assets. You know, increasingly, we live in a digital world. How many of you have email? It's about everybody. How many of you use some form of social media? Statistically, 65% of people over age 60 are using social media. 85% use email. Over 80% use social media daily. Plus, we do things like TurboTax or bill pay or online bank accounts. Now, it used to be when we passed away, somebody could look at the various documents, figure out what was there, and start to clean up the estate. The problem is now, these things are digital. Unless somebody knows that you have them, that they could really go unnoticed. So, when we look at these types of digital assets, the first type of thing to think about be logins and passwords. If we have bank bank accounts, if we have email accounts, if we have family photos stored on something like Snapfish or Dropbox, it's very important that somebody knows where they're at and can access them. So, how does an executor get access? Well, obviously they have to know your username and password. The second type of thing is correspondence, particularly email. If you have an email account and use it to communicate, whether it's with your mortgage company or you've elected electronic only statements from someone like us, again, unless somebody knows to look at it and they have access to it, those types of assets might get overlooked. The last type of thing are things that actually have value. PayPal accounts, eBay accounts that have money in them. Some of the online games, these avatars where you can sell them. Website names, a URL, www.mentor.com. Those things all have value and need to be included. Web-based medical records. More and more, the local hospitals are storing your medical records electronically. Family photos. Everything from recipes to sermons. And typically, the providers of these, when you sign up, there's some big agreement, and you check, agree. Well, most people don't ever read that. And typically what it says is, if you pass away, that stuff gets deleted or disappears. Now, the law typically lags these types of things in catching up. So, for example, with Google, if you have appointed a digital executor, you have given them an email to that person, you provide letters of appointment from the court, you provide your driver's license and a death certificate, they may let you access someone's email. I mean, that's just the first step. A lot of hoops to kind of jump through. So, one of the things that's nice, and we've included in your handout, is a list of the state laws for every state. Ohio currently does not have any law related to digital assets. The first law was just passed about 5 weeks ago in Delaware. And essentially, it's called the Fiduciary Access to Digital Assets and Digital Accounts. And what it says is that if somebody is properly appointed, they have access to those assets, just as if the person who had set them up does. And I think other states will start to follow. So, the first thing we'd suggest is create a list or a spreadsheet with all of your usernames, all of your passwords, and put it someplace people know where it is. And I know that runs counter to what you're always told, don't write down your passwords. But it's the only way someone's going to be able to access it. If you drop it in some electronic vault, whether it's with us, Raymond James provides a free storage, or a Dropbox or Skybox. It's a good way for someone to be able to start to locate these types of things. Second of all, you should express your wishes, preferably in writing, about who should and should not access this. Someone might have several children and they're communicating via email to one of the children about another one. It's like, I know your sister's a putz, but she is a little stupid, but we don't want her to read that. So who has access to the type of things? So you want to appoint a digital executor, just like you have an executor for the rest of your estate. And this could be someone different than the executor of your real estate. When you update your documents, and we recommend you update your estate planning documents at least every 3 to 5 years. And if you've not done it since 2012, you should have your attorney look at them to make sure they reflect current law, but also your current wishes. But in those documents, grant powers to your trustee or your executor to access digital assets. Check with the providers that you work with about what they require. Facebook, for example, you can elect for your pages and your photos and all the stuff you put in to become a memorial page. If you don't, they just delete everything. It just disappears. And then the last thing is, we recommend referencing digital property in a memorandum in addition to your personal property memorandum in your estate planning documents. So, digital executor, list of property, and a spreadsheet with usernames and passwords that you actually update. If you don't update it, it's not going to help. Let's talk about IRAs for just a minute. For most people, their IRA is their biggest or second biggest asset after their home. When IRAs were created, they were never really meant or designed for the amounts of money that are in them today. They're meant to smaller accounts. And so the beneficiary designations tend to be very limited, and what you can do with them tends to be very limited. The other problem is there's no provision if you're incapacitated. Again, if you're not deceased, but you're unconscious, there's no mechanism to manage the IRA. Now, you could give somebody power of attorney, but again, it's not built into the IRA itself. The other problem is, while IRAs are somewhat protected from creditors for you and perhaps your spouse, inherited IRAs are not protected from creditors. So you lose some of that protection once you pass away. So some of the questions we have to ask are, who's going to take care of my IRA if I'm incapacitated? Who's going to manage it? How can I keep my beneficiaries from wasting their money? If I give all this money to my kids or grandkids, what's to prevent them from just blowing through it? Or how can I make certain my beneficiaries be protected from creditors? Or perhaps even my spouse. Especially in the case of second marriages, I want to make sure the kids from the first marriage get something. I want to help my second spouse, but I don't want him or her writing the kids out. So how do I deal with that? A trust deed or an enhanced IRA can address basically all of these issues. And essentially, there are two phases to this. The first phase, it works just like your IRA today. You manage it, you control it, you can do whatever you want. Change beneficiaries, etc. The second phase is where you're unable or unwilling to manage the IRA. And in this case, the trustee steps in and manages it for your benefit and then for the benefit of your beneficiaries. Now, if you're incapacitated, that's a big benefit. Once you pass away, your beneficiaries can be unrestricted. They just get the money and it's theirs. Or you can put restrictions on it. And you can put just about any kind of restriction you can think of. The only rule is the beneficiaries have to take out the required minimum amount each year based on the IRS rules. But beyond that, there's nothing you can't do. So you could say, if I pass away, my wife gets the required minimum, but she can't touch anything else except for medical. And when she passes away, it goes to my kids. We did one. I call it, if you don't make it, you can't take it. Basically, it says the kids can only take out as much as their W-2 income. The more they make, the more they take. If they don't work, they don't get anything. I have one, and the kids don't even know this. It's 3 kids. The IRA is probably $2 million. Any child driving a GM vehicle gets the money. Because the person worked at GM. If none of the kids are driving a GM vehicle, it all goes to the Humane Society. They don't get anything. We've seen ones where the kids have to be drug tested. You can put grandkids, you can put charities, you can put pretty much anything you can come up with as a beneficiary, and you can change it at any time. The trustee IRA, when you set it up, you would want to work with your attorney to make sure the language is the way you want it. But it's basically a checkbox form. So it's very simple. It's very inexpensive. In the self-directed phase, the standby trustee will typically charge a nominal fee. There are only 2 companies that can do these currently. The IRS is private letter rulings for Bank of America and for Raymond James. Raymond James charges $1,000 a year to stand by. And they do all the filings with the IRS and all that sort of thing. Once you pass away or they become the trustee, it's about 1% a year. But we've had cases where people have kids, and frankly, they don't want one child being put in the position of telling another child no. You know, it's an awkward thing to do. So they'll name a trust company as executor for the estate and then deal with the enhanced IRA. So the restrictions, as I say, can be pretty much anything. You could stretch these out. Now, one of the things that's nice is traditional IRAs are protected from creditors for up to about $1 million. If a spouse inherits it, they are protected as well. But once it goes to another beneficiary, it's no longer protected from creditors because it's considered found money. With the trustee IRA, because it can have spendthrift language, because the beneficiaries are restricted, this is protected from creditors. So it does add, something over and above the other potential benefits. So basically, it does offer the maximum protection you can get. So who does it make sense for? First of all, somebody that doesn't have family members, or frankly, they're concerned about the financial acumen of their family in the event they're incapacitated. Say, look, if I'm unconscious for a year, I want my spouse, my kid, or my nephew to make medical decisions, but I don't want them managing the money. I don't want to wake up and find it's all gone. So that situation. Or somebody that doesn't have beneficiaries. Instead of giving the money outright to a charity, may want to have it distributed over a period of time. And again, we had a meeting today with somebody that was basically concerned about their spouse, remarrying and the money disappearing. This happens to be a first marriage, but especially, in second marriages, particularly where the spouse is younger than the first set of kids. People sometimes worry about this. And you can put those provisions in. It says, upon my death, my spouse gets income. They can dip in for health, education, maintenance, but they cannot change the beneficiaries. That goes to the kids. Or the last thing is, again, where you're concerned about the ability of kids or other beneficiaries to manage the money. So by putting restrictions on it, you kind of protect them from themselves. And again, you could put language in it, they could access it for health, education, first time home, pretty much anything you think of. But the enhanced or trustee IRA could be a nice tool. It's relatively simple to set up to kind of fulfill some of the estate planning needs. So with that, I'd like to introduce Ron Wayne and Amy Friedman. You should have a second handout from them. Includes their background and their contact information. So, Ron.
Well, hi everyone. My name is Ron Wayne, and first thing I want to do is to thank Randy for letting us be here today. You know, Randy's a very influential guy in this part of the world, and he has lots of access to lots of legal advisors, so we're really delighted and appreciative that you would ask Amy and myself to speak here today. I also want to thank Amy, who you'll meet in a few minutes, for kind of jumping in at the last minute in the programs that you received. David Woodburn, who is the practice group chairman of the Trust and Estates Group at Buckingham, Doolittle and Burroughs, wanted to be here today, but unfortunately he had a family emergency in Wisconsin. So at the last minute, we polled our members, and Amy was good enough to step up and say that she would talk to us today about the Legacy Trust. So thanks to my partner, Amy. You know, I'm here to be a cheerleader on behalf of the state of Ohio. I can tell you that I grew up in the city of Cleveland, east side of Cleveland, went to the Cleveland City Schools, went to Cleveland State undergraduate, Cleveland Marshall Law School, so I am a Clevelander all the way through. And I can't remember a time when both Cleveland and the state of Ohio has been on such an upbeat mode. I mean, we got LeBron James, right? LeBron is back. We got Johnny Football, and we win a home opener. I mean, when is the last time that happened? So we've got lots of good things going on here, and lots of good things in Lake County. I mean, the Metro Park system here and all that's transpiring, lots and lots of positive things. So one other great thing about what's been going on in the state of Ohio is some legislation that's been passed over the years which addresses some of the needs that have come about in trust and estate planning. So we're going to talk today about why Ohio is such a great state in which to do estate planning. I loved Randy's topic, why Ohio is a great place to die, but today we're going to talk about why it's a great place to live, and also why it's a great place in which to do estate planning. So first thing we're going to talk about today is, in a general sense, some of these Ohio advantages that have recently come to the forefront. Well, first of all, in 2007, Ohio passed the Ohio Trust Code, which is a uniform law, and it codifies what had been a bunch of hodgepodge regulations about how you create a trust, what it can do, what it cannot do, who can be your trustee, what are the distribution provisions. So in 2007, the Ohio legislature adopted the Uniform Trust Code, and as a result of that, when I do a trust for you and when you do a trust for your family, you can be certain as to what the results are going to be. And it also contains a whole bunch of provisions about how we fix trusts in the event that they don't work as well as they should be working. Maybe even more importantly, in 2012, Ohio passed a new power of attorney statute. And under that power of attorney statute, there's a whole host of safeguards for elderly folks and incompetents who had been victimized by people using powers of attorney. We have an inheritance controversy group in our firm, and we see unbelievable things happening under powers of attorney and undue influence, such that elderly folks, typically without a family, might grant a power of attorney to somebody that they don't know very well. Sometimes it's even a healthcare worker, sometimes it's a neighbor, and the next thing you know, that power of attorney is being used to change a beneficiary designation on a bank account or a life insurance policy to that healthcare worker, excluding the family from an inheritance. So this new law put in a bunch of safeguards that is really effective in trying to mitigate elder abuse. As Randy mentioned, there is no Ohio estate tax since 2013. This is a huge development. We're right up there with Alaska, Florida, Delaware. No estate taxes when you pass away. And Ohio used to have a very nasty estate tax. It was 7% of any amount over $334,000. So what did that mean? It meant that, before your children inherited, that there was going to be 7% just taken away off the top by virtue of the fact of the Ohio estate tax. There was never a tax on property that was being transferred to a surviving spouse. But before the kids got their inheritance, this tax would sweep away 7%. Ohio has never had a gift tax. You know what a gift tax is? It's a tax that's levied on your transfer of property to a child or a grandchild. Well, fortunately, Ohio never had one of those. And what Amy is going to talk with you about in about 7 minutes or so is the Ohio Legacy Trust. And this is what's called a domestic asset protection trust. It's the third best in the country, right behind Alaska and Delaware, which were the leaders in this. Now, what I want to make clear to you is that when Amy talks with you about the Domestic Asset Protection Trust in Ohio, called the Ohio Legacy Trust, this is not going to help you qualify for Medicaid. One of the factors, or one of the bullet points that we had in the brochure was long-term care asset planning. And I just wanted to touch on this for a minute because obviously Medicaid planning is a seminar that could go on for hours and hours. But make no mistake about it, when we're talking about Medicaid planning, we're talking about poverty planning. We're talking about taking your assets and giving them away to somebody or something and then waiting the appropriate period of time to apply for Medicaid. And Medicaid, by the way, is run by the same social service agencies in Columbus, Ohio that run food stamps and welfare. It's a place you don't want to be unless it's an absolute necessity. So we could talk about Medicaid planning at another time, but we're here to talk today about wealth transfer and wealth accumulation. So in Medicaid planning, the difficulty is that you lose control of the asset, and we don't want to do that. The way that you qualify for Medicaid is to make yourself absolutely broke and transfer assets to your children or to a trust, and then you're dependent, and in some cases beholden, and in some cases betrayed by the person that you gave the money to. So when Amy is talking about this domestic asset protection trust, it's going to be to insulate your assets from future creditors, not to help you with Medicaid coverage, okay? All right, so now we're going to talk about some very friendly Ohio statutes. And the first is the homestead exemption, which has been increased in the state of Ohio to $132,900. What does that mean? Under the old homestead exemption statute, if you got sued and you had over $12,900 of equity in your house, you could lose it to a judgment creditor. This could be from a contract claim or from a car accident. So Ohio has moved up a little bit into the 21st century in this regard and increased it to $132,900. If your house is owned by a husband and wife, you can exempt twice that amount from a creditor's claim. So this is a positive development. We're not quite to where Florida is. Remember O.J. Simpson, who bought the $8 million house in Florida? Guess why he did that? Florida has an unlimited homestead exemption, so we're not quite there yet, but we're moving in the right direction. We do have fairly decent exemptions for creditors' claims against IRAs, pensions, insurance policies, and proceeds. So those are two things that I just mentioned that are good lifetime protections in Ohio. There are also two really good death time protections for estates in Ohio, and they are that there's a creditor's claim statute, which is about the friendliest in the country. It says that if a decedent dies, anybody that is owed money by that decedent has to file a claim against their estate within 6 months after the date of the death. Well, guess what? Most creditors don't find out about the death. Credit cards won't necessarily know. Old hospital bills won't necessarily know. And so as a result of that, a lot of bills don't have to be paid when a decedent passes away, if 6 months elapses between the time of the death and the time of the creditor's claim. There's another very favorable position in Ohio, and that is that if a decedent has debts when they die, those debts are not payable out of non-probate assets. So joint and survivorship, transferable on death, designated beneficiaries, all of those assets can pass to your heirs and not be reduced by the payment of creditors' claims. That's another very favorable thing about the state of Ohio. I'm going to make you feel better about the state with the next slide. And that is, in Ohio, if you have a trust which is clunky, which is not running well, which is not getting the result that you want, we can fix it. And we can fix a revocable trust, which is probably what all of you have, a revocable living trust, by simply amending it, because you reserved the right to do that when you drafted the trust. But these methods that I've put here on this slide are available for even trusts that are supposed to be irrevocable and unchangeable. So these are things that the Ohio legislature has created in order to help Ohioans fix their broken trusts. I don't have the time to go through each of these, but I did want to point out that we can get good results if we have the cooperation of everybody that's involved in the trust, as long as we're not defrauding the IRS, as long as we're not defrauding creditors, we can fix broken trusts. And these are all the different ways that you do it. Private settlement agreements, judicial settlement agreements, and reformation pretty much mean that the parties get together and decide what's in the best interest of the trustee, the beneficiaries, and the settlor of the trust. Decanting means that the trustee can actually take the assets out of one bad trust and move it into a better trust, as long as no one is being harmed. So these are things that will, permit people to get out of a trust what they intended to get out of it in the beginning. I also wanted to point out to you that Ohio has one of the most favorable limited liability statutes in the country when it comes to creditors' claims. So, these things are all going on behind the scenes, but when you bring them together, it really makes Ohio a great state in which to do estate planning. We have a couple of other real advantages under the Ohio Trust Code. One is that we can do what's called a wholly discretionary trust. If you have a disabled child and you want to make sure that their Medicaid benefits will continue, you can create a trust and they can have the best of both worlds. They won't be disqualified from Medicaid benefits, yet they can have the benefit of the assets that you put inside of this trust. And the reason that is because the trustee has unfettered discretion. When we say wholly, we're not talking about H-O-L-Y, we're talking about W-H-O-L-L-Y, a wholly discretionary trust where nobody can make the trustee make a distribution, and because the beneficiary can't compel a distribution, neither can Medicaid. So we usually pick a very friendly trustee, such as a brother or sister of the disabled child. Next is this Ohio Legacy Trust, which Amy is going to talk with you about. And honestly, rather than having to visit your assets in the Cayman Island or the Isle of Man, where most offshore trusts were being done, you can do that right now in the state of Ohio. You can visit your assets in Chardon, Ohio, instead of having to worry about some republic that's going to collapse as a result of some political disarray. All right. Most importantly, I think, for tonight's discussion may be this section on the new Ohio Power of Attorney statute that was enacted in March of 2012. The first thing I want to tell you is that your old power of attorney doesn't have to be compliant with this statute. If it was executed before March of 2012, yes, you should review it. And I fully agree with Randy when he said review them every 3 years. But if you're doing a new power of attorney, you have to be compliant with the statute. And the real benefit of this statute is that it does provide increased protection for seniors and incompetents, because if you're going to give a power to somebody, like to change a beneficiary designation or to make a gift on your behalf, it has to be specifically stated in the power of attorney. We don't want people taking the old vanilla Ohio legal blank power of attorney form that says, I grant the power of attorney to my cousin to do anything that I could do We don't want your cousin to be able to change your entire estate plan just by virtue of the fact that you gave him this generic power of attorney. Another great thing that you can do with the power of attorney is to designate a pre-need guardian. So in a power of attorney, you can say, look, if despite my will, my trust, and my health care documents, it becomes necessary to appoint a guardian for me because I've become neglectful of myself or a threat to others, I want you to appoint the person that I've designated in this document, not the next person that's on the probate court's judges list to be appointed as a guardian. So it's another great reason to have a new durable power of attorney. I'm going to skip over the next slide because I think I touched on these things, but these are the powers that were being abused in the past. This is what the caregivers would be doing. You know, with a power of attorney and a form, they would be changing beneficiary designations. They would be amending your documents behind your back. They would be changing the beneficiaries on life insurance policies. So if you're going to grant these very important and broad powers, which are now referred to as hot powers, you specifically have to state that in the document. Okay? So Randy talked about what a good tax atmosphere that we're in now. So Ohio has no estate, gift, or generation skipping transfer tax. Unbelievable. Never been like this in 30 years of practice for me. There is no estate tax and there was no gift tax anymore. Under the federal estate tax regime, there are such high exemptions that we used to agonize over federal estate tax consequences, and we don't necessarily need to do that anymore if your estate is less than $5.34 million, which is indexed for inflation, by the way. That's a number that's going to continue to increase. What does that mean as a practical matter? When we visit with you about estate planning, we don't have to spend all day talking about federal estate tax. When I started practicing, the government started taking an estate tax after $650,000 in assets. Now it's up to $5.3 million. It's amazing. The gift tax exemption is also $5.34 million. So the question that's always asked is, hey, can I give away more than $14,000 per year to my kids? And the answer is a resounding yes. If you give away more than $14,000 in a year to your kids, all you have to do is keep a record of how much you've given, and you're only eroding your $5.34 million exemption by the amount in excess of the $14,000. So I think that, we've talked probably enough about taxes today, and I think what I would summarize in saying is that with reference to Ohio and federal estate taxes, the atmosphere has never been as favorable as it is today. And that's why Ohio is a great state in which to do estate planning, and that's why this is a wonderful time in which to do estate planning. Randy touched upon portability of the exemption, and this is the ability of a husband and wife to, if they do good planning, or in some cases no planning, transfer $10.6 million to your kids without having to worry about federal estate tax laws. So this is, again, as good as it's ever been under the 30 years of my practice. Last thing I wanted to point out to you before I turn this over to Amy to talk about the legacy trust is that if you're going to claim the benefit of this portability exemption, you really need to file an estate tax return upon the death of the first spouse. And that is so that you can claim the exemption. That's how it's done. Generation skipping, we're going to pass on that. Generation skipping is the notion that if you're going to make a gift if you're going to make a gift to a generation which is one below your generation, in other words, you're going to make a gift to grandkids or to great-grandkids, the government also imposed a tax on those sorts of items. The exemption for that is also now $5.34 million. So there's a tremendous amount of flexibility that's built into the statute, and estate taxes aren't necessarily the concerns that they were before. If they are, we can address them, we can deal with them, but they don't have to be the focus of our planning any longer. So with that, I'm going to turn it over to Amy, who's going to talk with you about a really special trust that's just been created in Ohio called the Ohio Legacy Trust. Thanks, and you know what? I'll be back in just a few minutes to kind of, pull things together, and then we're all going to take questions, Randy, Amy, and I, that you may have. So thanks for your attention. I'll be back in just a few minutes. This is the thing that he's asking you not to touch.
Okay, thanks. Thanks, Ron, and thanks again, Randy, for this opportunity. I'm just here to give you a brief overview of this new trust that's come into effect in Ohio, and it's another tool in your estate planning toolbox that might be useful. And the thing that it allows you to do is put aside some of your assets, a nice nest egg, and generally speaking, protect it from creditors. It's a self-settled asset protection trust. Self-settled means you create the trust yourself and you fund it with your own assets. So in that way, it's similar to your revocable living trust. But unlike that, and for the first time in Ohio, you can retain a beneficial interest for yourself. You can be one of the beneficiaries of the trust. You can also grant yourself several useful powers over the trust, and at the same time, like I said, you're barring certain creditors and cutting them off from being able to access those assets at a later time. This came into effect in early 2013, so we're about 18 months into having legacy trusts. And before that, you could not set up a trust for yourself with your own assets that you could bar your creditors from attaching in any way. As Ron had pointed out, you'd have to go offshore. The Cook Islands was a popular destination, and I know sometimes when the winter gets cold, we'd like to all go there, but not necessarily to leave our assets there. So now we're one of the minority of states. Each year about a new state adopts one of these, but we're only one of 14 right now, and that makes us one of the leading states in the nation to have these domestic asset protection trusts. So just there are some key requirements because this is something that's set up under the statutes. So you have to follow the strict guidelines under Ohio law to create one of these. The first one is a real basic requirement. There has to be a written trust instrument. The second is that unlike your revocable living trust, you have to provide expressly in the agreement that the trust is irrevocable. In other words, you can't change the terms of the trust once it's in place. So yes, you are giving up some degree of control by setting up this trust. You have to provide that Ohio governing law will control how the trust is administered. You can name a number of different trustees, and they don't all have to be in Ohio, but you do have to name at least one qualified trustee, and what that means is you can name an individual who's a resident of Ohio, or you could name a corporate trustee, a bank or a trust company that has a field office in Ohio. They need to have some custody of at least some of the assets in Ohio, even if they're a national bank. They need to maintain connections with Ohio and manage the tax returns, for example, and materially participate in the administration of the trust. So they can't be a trustee in name only. They can't serve as a straw man trustee. They have to be actively involved as an Ohio qualified trustee. And finally, one of the most important things to put into your written instrument is a spendthrift provision. And what that generally says is that any beneficiary, yourself or any of the other beneficiaries you may include, are prohibited from parting with the assets, their beneficial interest. They can't sell their beneficial interest in the trust to a third party. They can't pledge it. Creditors can't reach it through a judgment. So that is the critical piece there that makes this, cuts off the creditors from these assets. So once you have the document in place, you can name yourself as a beneficiary, as I said, but there are several other rights and powers that you can reserve as the person transferring the assets into this trust. You can grant the trustee the right to distribute income and principal to you in the trustee's discretion. In other words, the trustee would decide when to distribute, when not to distribute. The safest standard to put into the trust is to call it a wholly discretionary trust. And Ron touched on that a few minutes ago. Basically, what you're saying is you're not putting in any kind of special language saying you should distribute trust assets to me for my health needs or for my maintenance needs. You're putting it solely in the judgment of the trustee, the sole, absolute, and uncontrolled discretion of the trustee, whether to administer and distribute assets to you. But at the same time, you could go further. You can give yourself the power to demand and withdraw up to 5% of the principal of the trust each year. Additionally, you can grant yourself the right to receive all of the income of the trust if you choose to do so. And what's nice, if you put a vacation residence in a legacy trust like this, for example, you can grant yourself the right to use the trust assets and to enjoy the trust assets. You might put personal property, such as a boat, or a vacation residence, as I mentioned, or any other nature of assets that you might want to still be able to use, but shield from those creditors. You can grant yourself the power to veto a proposed distribution. If the trustee's coming to you and saying, I think I am going to exercise my discretion and give you these assets, if you sense that maybe that's not such a good idea for what's going on with your situation, you can grant yourself the right to cut that off and say no. And something that is similar to your revocable living trust is that you can grant yourself a testamentary power of appointment. And that's where on the back end of this, you do have a little bit of wiggle room. Even though the trust instrument is irrevocable and you can't change the terms of that trust, you could say, upon my death, I want these assets to pour into my revocable living trust, and that's the trust that you can amend and change up until the time of your death. So it does give you a little bit of an out on the backside of things. You can grant yourself the power to remove and replace the trustee within some reason. You can't appoint yourself as a trustee, and you're still going to need to have one of those qualified trustees. And if you name any trust advisors who are going to direct the trustee, for example, with respect to investments or otherwise, you can grant yourself, reserve the power to remove and replace them. In fact, you could name yourself as a trust advisor only as far as directing the trustee with respect to the investments. You can't have control over whether they're going to distribute assets to any of the other beneficiaries, though. So those are some of the interests and powers that you can add once you're putting this document in place. Once you've got the document signed, the next option is, how am I going to fund this? And the term in the statute is a qualified disposition. And what that means is you're picking and choosing assets to put into this trust to protect, and you have to complete what's called an affidavit of solvency when you fund the trust. You're basically stating under oath that you own the assets, you didn't come by them illegally, you have the legal right to be transferring the assets. If you have any known creditors at the time, you need to list those on your affidavit and disclose any pending litigation, for example. And you're making an express statement under oath that you're not trying to make this transfer to specifically defraud any known creditors. And that protects you on the back end, so that if a challenge does arise, you've got that in the file as a good piece of evidence that you've thought this through and you've looked at the big picture, and you're doing this for the right reasons, to protect a nest egg for yourself. So getting to that point, once it is funded and you've made one or more qualified dispositions, you might wonder how the creditors are affected by this. Well, if you are a creditor who came into play after the person has created the trust and funded the trust, you only have 18 months to raise any kind of a challenge to that transfer to try to reach the assets. And that's one of the shortest periods of time, the statutes of limitations, across all of the domestic asset protection trusts that we have in the United States. In fact, I believe 18 months is the shortest right now. Some states allow the creditor to reach the assets, or at least try to, up to 4 years after, or 2 years. But Ohio is favorable right now because we have this shorter time period and window in which they can challenge such a transfer. If you are someone who married someone who already had a legacy trust in place and who already funded it, then you're going to be out of luck. The post-transfer spouses cannot try to attach those assets in a divorce and cannot try to tap into them for alimony or spousal support in any way. The way that a creditor would try to get at the assets would be to bring what's called a fraudulent transfer claim, and that's on the slide there. Basically, the argument is, I'm a known creditor to this person, and this person specifically funded this with this asset with a specific intent to defraud me. There's a very high standard of proof required to succeed on such a claim. And the other interesting aspect that's not on the slide in Ohio is if the attorney fee wise, generally the American rule is you can't force the loser to pay the winning side's attorney's fees. But with these legacy trusts, as a deterrent to fraudulent or to a flippant lawsuit just trying to intimidate, the loser pays. And that might also give the person funding the legacy trust pause and take it seriously and do that affidavit and make sure that they're not going to be on the hook for paying the creditor's attorney's fees if they lose. If you are a creditor who already existed when the person funded the legacy trust, you still have the 18-month period, but they grant you a little bit longer time. You have to file suit within 3 years of the transfer, and in addition to that, you have to have filed the claim within a 6-month period of time that the court would think you should have been aware that that transfer was made. So it's still a really tight window there. If you have secured property, that's not really a good option for using to fund such a legacy trust because the lien follows the collateral, so you can't cut them off with a trust like this. And in addition, there are certain exception creditors under the law. So I talked about the post-transfer spouse, but if you were already married when you created this trust, those are the types of spouses or former spouses who can try to get a court order for alimony or a property division based upon what's in these trusts. And any child support order is always going to be attachable to these kinds of trusts. That's one that just for public policy reasons the state didn't want to bar that kind of a creditor from accessing these trusts. So this slide provides you with just a basic list of when or what types of people might find a legacy trust useful. One that comes to mind right away when I talked about the spouses is if you've got some assets, maybe you're a young person who's contemplating getting married or isn't even married yet and came into some family money or are taking on a share of the family business. It's always touchy in our field to try to negotiate a prenuptial agreement, and sometimes you get right up to the date of the wedding and things are very emotional. This is an out. This is a way to get around having to do that. The fiance could set up a legacy trust for himself or herself, and that's going to protect those assets down the road after they get married. Now, we still probably would recommend, if you can, to also do a supplemental prenuptial agreement just as a belt and suspenders approach, but if you do nothing else, setting up a legacy trust with a nest egg or with some certain family assets is a great way to get around having to deal with that emotional issue. Other candidates that we've talked about as estate planners are lottery winners. This might be a nice way to shield what you've won in the lottery if you hit that big number, because people are going to come out of the woodwork and start asking you for money, and if you've locked it up for yourself and named yourself as a beneficiary, then you've got an easy way to say no. Maybe you've got a personal injury award coming. That might be another nice option for setting up a legacy trust with. Any accountant, any lawyer, doctor, any of us who have worries about professional liability are starting to think about maybe setting aside small nest eggs similarly with a legacy trust to protect those assets. But anyone, really, the idea is to take some money that you have that you don't really have to live on. If you've got a nest egg that's there and you want to save it for a rainy day, and you don't know, you might get in a car accident and your liability coverage doesn't cover it all. If you've got it in a legacy trust ahead of time, that's something that's going to be preserved for you. So just to wrap up really quickly, we talked about what a legacy trust is and how it's funded and what some of the requirements are and what the bars are on the creditors and what they have to do in order to even try to breach that. There are some best practices when you go to set one up. And the first thing is due diligence. Disclosure, disclosure, disclosure. Your attorney and your financial planner and your team is going to ask you to lay it all out there, because the more you document what your assets are at that time, what liabilities might be out there, look at your income stream and what your potential income stream is, consider your casualty and liability insurance coverage so that you're doing a real solvency analysis, because unlike planning for Medicaid, when you're trying to plan for creditor protection like this, you can't impoverish yourself through a legacy trust, because that is evidence towards this being a fraudulent transfer, that you're really just trying to hide everything away because you know something's coming down the road that you're trying to hide it from. So you need to do a solvency analysis and disclose. Another good strategy is to name not only yourself, but perhaps your spouse, children, grandchildren. That way, if there are other beneficiaries besides yourself, there's a better argument that even if it's looking like a fraudulent transfer, the court might be less likely to take all of those assets, because it's going to harm other people besides just you. The other beneficiaries have rights as well. So that's a good strategy. And with respect to all of the powers that I had talked about, all the different options of withdrawing 5% or making sure you get all the income and so forth, try to narrow what you choose down to what you really need. And some of that might depend upon if you're also trying to implement some tax planning in addition to the asset protection aspects of a legacy trust. But that's always on a case-by-case basis. So don't just import every single optional power that you can give yourself. Try to keep it narrow. And once the trust is in place, you need to abide by the formalities. You need to make sure that you realize you're giving up control to this trustee. You can't have any kind of implied understanding or an appearance that anytime you ask for money, the trustee's just going to say, okay, we'll do it. There has to be a line between you and that trustee, and they need to keep good records. Because one thing to consider when there is a challenge, if there have been distributions that have been made from this legacy trust, the presumption is that the last asset that went into the trust is the first one that comes out of the trust. So that can get kind of messy when you're making multiple dispositions to the trust. But that being said, I think Ron touched on this. Ohio right now is ranked third in the nation in certain polls as far as the best asset protection trust, in the sense of we have that short statute of limitations of 18 months. We have very few creditors who by law can break through, such as child support orders and so forth. So it's definitely a good component to think about putting into your comprehensive estate plan. So the next part of this is Ron is going to wrap things up with some last thoughts about why we're in such a great state for estate planning. Thank you.
So we've been together for, an hour or so, and we do want to wrap this up, but it wouldn't be right if we just didn't pull it all together and say, so what do you do now? You live in this great state in terms of estate planning, you have all of these advantages, but unless you do something about it, it's not going to do you any good. So the first thing I would suggest to you is that, as Randy suggested, remember the six-pack? Boy, get those documents done and make sure that they're quality documents. I can't tell you in our practice how often people become incompetent or pass away without quality documents, and they sink into the safety net which was created by the state of Ohio for people that don't have these documents, and it's probably not where you want to be. So have good quality documents and review them every once in a while. Proper titling of assets. I'll just give you one story about this. When I talk about proper titling of assets, I mean looking at your insurance policies, looking at your bank accounts, looking at your brokerage accounts. Are they appropriately titled? Do they have a designated beneficiary, and is it the right person? Have you been through a divorce and forgot to take your ex-spouse off as the beneficiary on a life insurance policy? Believe it or not, it happens all the time. Now, one quick story. Have the worst failure to properly title an asset situation I've ever had. A gentleman works for the state of Ohio, a judicial official, has an OPERS plan, Ohio Public Employees Retirement Service Plan, put away money every year assiduously, very careful about making money, watching the money, growing the money, fails to designate a beneficiary, dies suddenly. has one sister, no children, no parents, no other nearest next of kin. The public employee retirement system says we have to pay the money to your estate. What's the problem with that? The money is payable to the estate over $700,000 in a lump sum. No possibility of an IRA rollover. Federal income tax, 39.6%. State income tax, 4.5%. It gets worse. He's got creditors. He bought Florida real estate at absolutely the worst time. He owes Bank of America, U.S. Bank, and everybody else in the world a boatload of money. The sister gets $142,000 at the end of the day. If he had checked the box that says, I appoint my sister as the beneficiary of this asset, she would have got the whole $700,000. I mean, that's how critically important this stuff is. So if you come away with nothing else from this presentation, and hopefully you've come away with lots of good ideas today, but it is to review, and as Randy pointed out, maybe every 3 or 5 years, visit with your estate planning attorney, take a look at these documents and make sure they're still relevant, make sure they're as good as they can be, and make sure they're appointing people as your executor, trustee, fiduciary, and guardian, the right people today. We look at documents that have been done years ago, and people can't believe that they name that person as either the guardian of their children, or their executor, and it's like, wow, what were we thinking? I don't know what you were thinking, but it's something that needs to be changed today and to be taken care of.
We do have a lot of stuff coming up, so I encourage you to check the website, and thank you again for coming this evening. Thanks.